All right, let's just jump right in. We've all had disagreements, right? Some small, some not so small. But what happens when you've got a serious conflict and you just can't work it out on your own? Your mind probably jumps to a courtroom, maybe some dramatic scene from a movie. But guess what? There's a whole other world of options out there. Today, we're going to break down the two main paths you can take to find justice.
So here's our game plan. First, we're going to solve the curious case of the vanishing trial. Then, we'll map out the two big paths to justice. After that, we'll dive deep into the world of ADR, see how it actually pops up in our everyday lives, get a framework for choosing the right path, and then we'll take a little peek into the future of how we settle our differences.
Okay, so our first stop is a genuine legal mystery. For years, the number of lawsuits that actually go all the way to a trial in a courthouse has been absolutely plummeting. So, where did they all go?
What is going on here? Why are we seeing fewer and fewer of those classic courtroom showdowns? Well, it's not because people suddenly stopped disagreeing with each other. Nope. The real reason is that the old system, the traditional way, has pushed people to find a better and, frankly, faster way to solve their problems.
And this isn't just a hunch, it's a real, documented trend. Legal scholars have been tracking this for years. The traditional court process, what we call litigation, has become unbelievably expensive, and it can just drag on and on. So what happened? Well, as they say, necessity is the mother of invention. The legal world had to adapt, and it had to embrace some new ideas. So this evolution has really left us with two fundamental ways to handle a serious conflict. You can think of it like looking at a map. You've got two different routes to get to your destination. On one side, you've got litigation. This is the big public highway. It's formal, it's run by the government, and everyone has to follow the same rules of the road. On the other side, you have alternative dispute resolution, or ADR. Think of this as a whole network of other routes, side streets, express lanes, scenic paths. They're private, they're way more flexible, and they're designed to get you to a solution without all the traffic jams. Now, if you really want to understand why litigation can be such a grind, look at step 2, discovery. After the lawsuit is filed, you hit this phase. This is where both sides have to show all their cards. Every email, every document, every piece of information. It can become a total black hole for time and money. Seriously, this one phase is often the very thing that makes people say, there has to be another way. So let's talk about that other way. Let's pop the hood on ADR and see how it works. If litigation is that rigid 5-step highway, ADR is more like a flexible toolkit. We're going to look at the 3 main tools you'll find inside. This chart lays it out perfectly. First, you have negotiation. That's the simplest. It's just you and the other side trying to hash things out. Then there's mediation. This brings in a neutral third person, a facilitator, who doesn't pick a side, but basically acts as a communications coach to help you find a solution together. And finally, there's arbitration. This is the most formal of the 3. You basically hire a private judge, an arbitrator, who hears both sides and then makes a final decision that's legally binding. Now, I know what you might be thinking. This all sounds very high level, very corporate, but the truth is, ADR is woven into the fabric of our daily lives, and you've probably run into it without even realizing it. I mean, think about it. Ever had to deal with a warranty issue on a new gadget? Ever seen a little clause in an employment contract or your cell phone agreement? Bam, you've just stepped into the world of ADR. It's used for everything, from really sensitive workplace and family issues all the way to massive business and even environmental conflicts.
And get this, it's incredibly effective. Just look at this data. The U.S. Equal Employment Opportunity Commission, the EEOC, uses mediation all the time for workplace disputes. And when they do, a staggering 70% of those cases get resolved. That is a huge number of people avoiding the stress and cost of a court battle. And if you need one single image to understand the biggest selling point for ADR, well, this is it. A typical consumer dispute that goes to court takes almost 2 years, 23 months to get resolved. That same dispute, when it's handled through arbitration, just 5 months. That difference is just massive. It's not just time, it's stress, it's money, it's your life on hold. Okay, so we've got the options on the table, but how do you actually choose? The key here is that it's not about which path is better overall. It's about which path is right for your specific situation. Let's be real, the first factor for most of us is time and money. And here, it's pretty clear-cut. As we've seen, ADR is almost always faster and cheaper. Some studies show it can be anywhere from 25 to 50% less costly than going to court.
For a lot of people and businesses, that fact alone makes the decision for them. Here's another huge difference: privacy. When you go to court, everything, and I mean everything, becomes a public record. Your name, the messy details of your dispute, the final decision. It's all out there. ADR, on the other hand, is private. It's confidential, and that's absolutely crucial when you're dealing with sensitive family issues or a business trying to protect its reputation.
Now, this right here is a really important trade-off. A court's decision has the full power of the government behind it. But more than that, it creates legal precedent. It sets a rule that can affect everyone else in the future. An ADR outcome is totally binding for the people involved, but it's a private deal. It solves your problem, but it doesn't change the law for anyone else.
And look, it is so important to understand that ADR is not a magic bullet. There are some really serious criticisms. One is this idea of the privatization of justice. If a company has a dangerous product, for example, settling all the complaints privately can hide a huge public safety problem. Then there's the repeat player issue. Think about it. A big company that does arbitration 100 times a year might have a built-in advantage over you, who's doing it for the first time. All right, for our last section, let's look ahead. Just like technology has completely changed shopping, medicine, you name it, it's now starting to revolutionize how we handle our disagreements. And the future is really already here. It's called ODR, or Online Dispute Resolution. The pandemic just threw this trend into hyperdrive, taking things that used to happen in a stuffy conference room and moving them online to video calls and special digital platforms. It's making the whole process even more efficient, and in many cases, way more accessible. This timeline just shows you how fast things are changing. It went from just an idea back in the 70s to a corporate staple in the 90s, and now we're deep in the digital age. Today, we're even seeing AI tools that can analyze thousands of old cases to predict how a new one might turn out, giving people more data than ever before to decide what to do.
And that kind of brings us to the final big question. This whole shift away from public courts and toward private, often online solutions, it gives us incredible gains in speed and convenience, no doubt about it. But it also forces us to ask something really important. As justice moves out of the public square and into private digital rooms, what are we gaining in efficiency, and what might we be losing when it comes to public accountability and the way our laws grow and adapt for everyone? Definitely something to think about. Thanks so much for joining me.